All right, well, we have three sets, three troikas already on the, or perhaps in the, having been enlightened by the Republican debates, maybe these are formidable triads here. So our first set of three is Chris Green, Larry Solom, and Steve Sachs.
A very interesting paper. One thing I wanted to highlight, page 13, the definition of originalism seems highly idiosyncratic. Original expected application. So Raoul Berger would be happy if he were still around, but almost everybody who calls themselves an originalist rejects that. So, and I think actually your paper almost reflects that change in originalism. So if you define, especially if you define, here's one way to define the distinction between rules and standards. Rules are things with a relatively small meaning application gap. So if you know what it means, you know what the rule means, there's not much more to do. Standard, well, I know what it means, but it's a standard. There's a lot more to do. There's a big gap between the meaning and application. Once you say, well, what I'm doing is, if the meaning determines it, largely, if it's a rule, then I go with that. But if the meaning doesn't, well, then I don't. Well, that means you're going with the original meaning for both cases and not the original application. So, my stuff on sense reference or just meaning application, Sinnbedeutung, if you want to put in some German. This is, the Scalia taking down the sign and putting up original meaning back in 86 or 87 or whenever. That's the same move. I think it's a really interesting way to translate that move into this other language, but I think it seems like the same move. One thing, you need original history to know what standard it is. So I think John Stiniford's work, the two different interpretations of cruel, they're both standards, but the question of which one, you have to go to the history to find out that. Finally, page 51, at one point you cite Searle on deriving ought from is. I think the details of Searle's argument actually are really interesting. The example is promising. Searle goes from the fact of a promise to the existence of an obligation. Article 6 is exactly that move. So that would be a great point to talk about Article 6. But great paper.
While Chris was talking, we got more triads already. So, Larry.
Yeah, thank you for the paper, Jamal. Really fascinating paper. And I just want to say I think it relates to an idea that's very much in the air, sort of the idea that the hardwired rule-like provisions of the Constitution, maybe those provisions should be treated in an originalist manner, and that everything else should not. So it's not just that I think your positive thesis is very interesting. I think it relates very much to current normative debates. So I want to just echo what Chris said about the idiosyncrasy of the definition of originalism, right? I would just say that what you define as originalism, I would define as non-originalism, and so and I do think that it's a very, very rare position, at least in contemporary constitutional theory, although evidentiary use of application expectations is quite common. So just two comments. One is that I think the paper equivocates on the rules versus standards and principles approach. I saw 4 distinct and inconsistent definitions in the paper. One focused on legal content versus fact-finding. The second focused on the employment of practical judgment versus non-employment of practical judgment. The third focused on intersubjective agreement versus lack of intersubjective agreement. And the fourth, the Razian definition, focused on the specificity of the rule with respect to covered acts. And I think that the paper would work better if this issue were addressed earlier, right? And I just would note that all 4 of those definitions are different than what I understand to be the standard definition of the rule standard distinction. Standards give mandatory normative considerations, right? I think this is Larry's definition. I'm not sure. But anyway, whereas rules provide a decision procedure that does not require direct resort to normative considerations. Second thing is that the paper on page 10, note 53, brackets the interpretation construction distinction. You probably know where I'm going now. So I think, in fact, the paper is all about the interpretation construction distinction. This echoes a comment Michael made, right, in different terms. When we are talking about the meaning of the constitutional text, either the semantic content or contextual disambiguation, then originalist concerns come to bear. And if the result of that process is outcome determinative, then we don't need to go any further. I'm just saying what Michael said in different language. But when the communicative content underdetermines the outcome, then sort of originalism has run its course. Now, it's very controversial whether this even ever happens, right? And different originalists have different views on that. But if you believe, as I think you do, that many constitutional provisions have communicative content that's underdeterminative, then of course originalism isn't doing work in the zone of underdetermination. That's because it, on originalist grounds, could not do that work, right, if the text requires precisification or some implementation rule. So I would urge you to at least say more about the interpretation construction distinction.
3 points. The first is a clarification point that I think I understand the paper better as a resulting response to Michael, but that would be something that would need to be done in the draft, which is the standard originalist response to the paper, I think, would be along the lines that Chris and Larry have said, which is that, look, it's unlikely that the application stage is going to involve a whole lot of originalist evidence, which is what you code as originalist. You know, if the question is this particular person 35 or not, we're just not going to be looking to evidence from the 1790s to figure that out. We're going to be looking to like birth records and stuff from a recent period, even if we're using a precisely originalist definition of what 35 years old means. So, likewise, you know, we might be using an originalist evidence for the choice of rule, or whether it's a rule versus a standard, or which standard is involved. In your paper, it seemed like your discussion of Justice White's view in Williams v. Florida seemed like you were saying that, yes, that's the sort of thing we should look to originalist evidence for, do look to originalist evidence for. Just now in your discussion of affirmative action, it suggests that in fact we do something different. It's not that we use originalist evidence to figure out whether it's a rule or a standard, and then if it's a standard, we apply the standard normatively in ways that don't look to originalist evidence. That would be what I think everybody who calls themselves an originalist at this table would accept. I think what you're saying is, in cases that involve standards, we totally go beyond the originalist evidence for choice of standard and just do something else. If that's your claim, then I think that it needs to be much more clear that that is the claim, because that actually would be a strike at sort of orthodox originalism in a way that the other view would, I think, be entirely compatible with it. Second point, if that's your claim that this is the positive practice, I think it becomes important to figure out what's important about positive practice. So suppose it were possible to demonstrate that the courts reliably discriminate against disfavored groups in criminal sentencing. We would not say necessarily, some people would say, not everyone would say that therefore the law in the United States is that courts shall discriminate against disfavored groups. I think we would say, no, that's something judges do, but it's something that they themselves would say they shouldn't do, and so on and so forth. So do we have any evidence on whether people think that this is a good practice, or do they purport to be saying that it may be true that our choice of standard is totally non-originalist, but we'll never say that. We will always claim that we're getting our choice of standard from the founders, even if we're not trying very hard. And then the third question is on the last point about standing. It seems odd to me the way you close the paper, which in general I like, by looking at standing as sort of a first best normative question, sort of what would be the best rule of standing to achieve our goals. Because I think that Scalia and other people, think they're getting standing from Article 3, and they might be wrong about that. But if they think they're following a constitutional rule that requires a certain output as to when governments can sue, then it's not at all perverse that they would come out with a rule that might not serve other interests, and they might just be wrong.
All right, Jamal.
Okay, so thank you. Those are all great comments. I think there's some overlap in in what was raised. So first thing I'll say, so on the definition of originalism is idiosyncratic. I agree with that, and that's intentional, and it derives from a fact that, well, I think will end up being relevant to my other answers, which is that the practice that I'm trying to describe, and again, bracketing whether I'm successful at describing it as a positive matter, but the practice I'm trying to describe is not theoretically motivated, right? So it's not as if I think that there's some theory that's being used to then apply to constitutional interpretation by judges. I'm trying to derive the theory from what I observe, right? And so I'd actually need a lot bigger N to do that in a way that's really satisfactory to me. But that's the enterprise, right? So whether originalist scholars are satisfied with resort to original intent or expected application is of no moment. If one wants to call it non-originalism, that's fine. I think when I use originalism in the paper, including in the title, it's really a shorthand for what I actually do I do think that the practice of originalism actually looks like. And again, we can develop conceptual distinctions that are interesting, that give originalism some integrity or not. But again, it's not, the paper doesn't start with a theory and then go to practice. It starts with practice. So as to meaning versus application, and I'll group these set of concerns together, and interpretation construction and how much this lines up with that set of, or that universe, that family of ways of approaching originalism. I completely agree with Larry that I should say more. So the paper that I think you have has one sentence on that. I've since revised it a little bit to have about 3 sentences, but I think it needs to be above the line. And what I'd say is, I actually don't think that what I'm suggesting lines up very well with the interpretation construction distinction, insofar as what I'm understanding judges to be doing is not necessarily taking a text, finding a meaning, and then deciding on legal effect. I think we can talk about whether that's what they should be doing, but not everything that I think of as a constitutional rule emerges from a text in any obvious way. The rule that says that Myers versus United States might be an example here, where I don't think that the court in Myers is interpreting a text. I think they're interpreting a rule that Chief Justice Taft thinks is in the Constitution, but I don't think it's a text, and I don't think it's about the meaning of a text in any linguistic, communicative sense. I think that there are rules embodied in the Constitution that don't take the form of text, and I think that's often what's going on. So while I do think I need to talk about interpretation construction more, since A, I don't think we're always talking about a text, and B, I don't actually observe in the wild judges drawing a distinction between meaning and application, or meaning and legal effect. I don't know, I'm not able to say that what they're doing is deciding on meaning and then deciding legal effect, rather than just conflating them in some way that resist a theoretical unpacking. So that's why I resist the distinction, but I think I probably do need to say more. Definitionally, how am I defining rules? I agree, different from the standard definitions. This goes back to the fact that I'm actually not trying to start with a theoretical definition and then apply it. I'm trying to start with, well, what do I think these different provisions have in common, in which I observe what I understand to be originalist, or I'll say historically bounded reasoning. So I do think I need to say more and be more specific early on. So I take that point, Larry. But I don't think I need to align myself with any particular theory. Stephen. So just your first example, whether someone is 35 or not, I don't understand that as being as raising a constitutional rule question. That's an application question. So whether they have to be 35 or not, I think would raise a rule question. And this goes back to something that Chris raised as well. You would think that you would need to be originalist in order to answer to do an originalist inquiry to answer the threshold question of whether something counts as a rule or a standard. The paper should say more about this. I think that's right. But I actually think that what we observe is that when we're talking about obvious standards, we don't see that inquiry at all. We don't see any kind of originalist inquiry in most cases, certainly not in majority opinions. But when we see provisions that look like rules that for whatever reason the judge wants to understand in terms of a standard, perhaps because they're motivated by a particular outcome or consequence of thinking about it in terms of a rule, we do see originalist inquiry, and originalist inquiry in order to say, no, actually what they meant was a standard. So I think you see that, you see something like that in INS versus Shada, for example, where the reason, you go into the originalist evidence in order to disprove that something's a rule. But for things like equal, things like do, I think you don't see that. And just on standing, I take the point that from Justice Thomas and Justice Scalia's internal perspective, they wouldn't be moved by my argument, but I think that doesn't mean it's not perverse. Sometimes adhering to what you understand to be constitutional meaning produces perverse results, and so that counts as a reason not to do it. Maybe not a decisive reason, but counts as a reason.
I would like to defend Jamal on the idiosyncratic definition of originalism, because even by Larry's formulation, original expected application, it can be used in evidentiary sense. I think in practice, the overwhelming evidence of original meaning comes from original expected applications, and so it seems to me when you're coding opinions to see whether history is doing any work, to look primarily at that is not going to lead you very far astray. Whatever the underlying theory of originalism is, that's the actual evidentiary basis for argument.
All right. The next triad here is Tom Colby, me, abuse of the moderator's prerogative, and Mitch Berman.
I think I share a lot of the same instincts about the paper that Michael and Larry shared, so I apologize if this is redundant, but I find myself still having trouble understanding the distinction you're drawing between constitutional rules and constitutional standards as you're defining them. So I'm hoping maybe you can do a little more to clarify the line. At one point you say Article 3 either abrogates sovereign immunity or it doesn't, so it's a rule. But of course the Due Process Clause either permits state regulation of abortion or it doesn't. Or the First Amendment either protects a right to hate speech or it doesn't. But those aren't rules on your understanding. So I'm not sure I'm totally getting the distinction. On page 9 you write, a constitutional rule is a constitutional norm whose scope of application is not expected to be subject to reasonable disagreement. But isn't that circular? Whether or not we expect it to be subject to reasonable disagreement depends on what interpretive approach we take to interpreting it. It can't itself be the determinant of which approach we're going to take. At least I don't think so. It's kind of putting the cart before the horse. I would think that whether we expect judges to exercise judgment in the application of the provision or not depends on what interpretive approach we expect judges to take. So if you could say a little bit more about that distinction, I think, as Larry said, spelling it out more in the paper is going to be important. But even now, for us to sort of get a real firm sense of what that line is, I think would be helpful.
Yeah. My comment, I now think maybe I understand the paper better than I did before based on Jamal's own response to the first set of comments. I would have said, an originalist is someone who looks for the original meaning of the text, and that meaning may reveal that it's a nice determinate rule, in which case then you just look to the facts to see how the rule applies. Or it could be a standard, in which case what the meaning is a direction to apply some sort of first-order practical reasoning to give content to the standard. But the second step is not interpretation. It's not something where one is originalist or not. Originalism runs out in determining the meaning, and other functions then occur subsequent to that. But I take it, just from the comments you made, Jamal, that you are inferring whether something is a constitutional rule or a standard by looking at what the judges do, how they treat it, which leaves which is it would be an odd approach for me. I would assume whether it's a rule or a standard is a question of the meaning of the text. How, if a judge is treating a rule as a standard, that's error on an originalist standpoint. But it seems to me that you're inferring the meaning, at least the way you're inferring the meaning of it, whether it's a rule or standard, from looking at how it's treated by judges rather than by its meaning, which just seemed somewhat odd to me. Mitch?
Jamal, I think I understood maybe unlike the rest people, I understood the paper after you and Michael spoke to it, sort of the way I understood it before. I think that discussion of originalism is a bit of a distraction here. I thought your thesis is the following. When decision makers in the U.S. constitutional culture believe or anticipate that a constitutional question was designed to be resolved in a way that minimizes adjudicatory discretion, then they tend to resolve it in accordance with their beliefs about how the framers or ratifiers would have resolved that question. So this gets in the originalism expected application. You don't have to say anything about originalism. You don't have to buy trouble with whether your idiosyncratic understanding of originalism is a form of originalism. This statement of your thesis is entirely untheorized, which I don't state as a criticism. I took that to be the paper. Just basically an observation. Hey, this is basically how we go about things. And it struck me as probably basically right, subject to the big worry I'm about to present. I really liked your discussion about the constitutional culture and methodology. There's an ambiguity here, it seems to me, with respect to the constitutional question. So the way your paper proceeds, I think, is that we ask a question about the scope of a particular provision. We've already focused on the provision, and the players in the constitutional culture ask, do we believe or anticipate that the framers would have expected this constitutional provision to be interpreted and applied in a way that minimizes adjudicatory discretion? That's, I think, sort of how you're picturing it. But when we ask about a constitutional question, we could think of it from the ground up. So instead of saying, does the Equal Protection Clause prohibit phi? We start with phi and we say, is this constitutional? So we first have to figure out what provision we're going to be we conclude resolves or adjudicates that question. If we think of the problem in that way, that latter way, which seems at places, I'm not going to try to identify the spots, but seems sort of the way you're flirting with it at times, then there's a big question, a big move that comes in when we decide, we choose the provision that we're going to then interpret or ask about. So to make this a little more concrete, take a question about excessive partisanship in redistricting. We could start off and say, is this constitutional? Or we could say, does the Republican Guarantee Clause forbid this? Or we could say, is Ted Cruz constitutionally eligible to be president? Or we can say, does the Natural Born Citizen Clause allow this? After all, it could be that the Natural Born Citizenship Clause prohibits him on something like the Thomas Lee rationale, but we think that on the full account, taking the Equal Protection Clause into account as well, he'd be permitted. Or we could say with respect to prohibitions on gun rights, like what Stevens does in Heller, I think, I can't keep him, or in McDonald, I can't keep him straight, but we could say this is a question about the interpretation of the Second Amendment, or we can say this is a question about the constitutionality of these prohibitions. And on the latter interpretation, or the latter statement of the question, unlike the former, we might move both to the Second Amendment and to the Privileges and Immunity Clause in the 14th Amendment. Right? We could say, no, the Second Amendment doesn't protect this, but it's protected under this other provision. So if I basically have your account right in the way I described it initially, I think that there's more, I'd push you to be more explicit and to think through the different answers you might get, whether we're thinking about initially the question of the scope of a particular provision, or we start with a question about the constitutionality of a particular challenged action.
Okay, thanks. So, so first on Tom, I'll just refer Tom to Mitch on what's the distinction. I think that I think that Mitch's definition is accurate, and that's the way in which I'm understanding the paper and the challenge in the paper. Now, Tom wants to know, well, doesn't it require interpretation to figure out this kind of threshold question of whether it's best to understand it as a rule or a standard? Doesn't it depend on the interpretive inference that one is drawing? The claim of the paper is that there are some provisions where you think it doesn't matter. Now, as it turns out, the reason they get litigated is because it turns out that it does matter what your interpretive approach is. But I don't think that that's necessary to the threshold question, because the point is, I mean, to take everyone's favorite example, although I run away from that example in this paper, it's a 35-year age limit. I think there are lots of provisions that we would expect to look like that provision, but turn out not to. Like whether a state redistricting commission is a legislature, whether a weekend is a recess, right? So, and sometimes those turn into hard questions. And so, even though they're hard questions, and this is the contention, we still want to know what the framers would have thought about that situation. Now, on Mitch's worry, his big worry, I was not trying to flirt with that bottom-up understanding. I think it's quite important in this paper to make clear that this rule standard question depends on the question on how the question is presented to the interpreter. So constitutional provisions are not rules or standards. Constitutional provisions include both rules and standards, and it just depends on what question you're asking about them. Constitutional practices are not resolved through rule or standard provisions or questions in any inherent sense. It depends on a bunch of threshold questions that you have to ask in advance. Now, in cases, which is my data set, we know what the question presented was. Now, that's not going to always be the case, not even in every Supreme Court case, and maybe even less so in the lower courts. So, there's more work one could do in piecing through how I would describe the practice of constructing what the question is. But I think, at least in some large subset of cases, the question presented is presented by the litigant in a very particularized way. And so that's the question that the judge is answering.
Okay. Just a state of play announcement. The next trio is Ian Bartram, John McGinnis, Richard Fallon, and then the next one is Naomi Rao, Richard Ray, William Daley, and the next one is Stephen Semorano, Thomas Lee, and John Harrison. I think being brief will ensure that we get through all of those, and we probably shouldn't take any more hands at this time. So, Ian.
So in the effort to be brief, I like the paper a great deal, and I think I'm sort of in Mitch's camp, so maybe I can be short. I wondered if it might be useful to think about this in terms of a judge thinking about what do we want, or what do we value the Constitution as doing in this kind of sort of a circumstance, this case? What purpose does the Constitution serve for this sort of a question, right? What values might we have? And if in some cases a judge thinks a rule, the Constitution needs to provide a rule for this case, then, right, we might choose an interpretive method, right, which is going to provide a kind of more rule-like thing, and that ends up looking like an originalist or textualist or something like that kind of perspective. If we think that the value of the Constitution here is to provide some sort of standard or principle which develops, right, then it might be that because we have that value for the Constitution, we pick an interpretive methodology that's more dynamic, prudential, whatever it is down the road, and that it might in some way be what Mitch is saying, that the question of what's the Constitution doing is what's informing the methodology choice, and then the way it plays out in the data set is that it looks like, you know, to serve that value, we're picking this kind of interpretive methodology, if that makes sense.
John? I understand the way you've found the question that at least I and others found so necessary, the question of why you shouldn't look at originalism to decide whether it's a rule or practice. You define, it's really by defining it as a practice, that judges actually just see some rules and then they look to originalism, otherwise, and that's sort of their decision. Mike, one question is that right? Aren't there instances in which judges debate the question whether it's a rule or a standard by reference to originalism? I see some of the Frankfurter Black debates like that. And then even assuming that's not the case, don't some of your other justifications, wouldn't they also go to looking to originalism to make the decision between standards and rules? After all, you point out that there are a lot of good reasons to have rules and standards. If we don't actually go and look at whether these are rules or standards, why they chose rules or standards, doesn't that undermine some of the teleology? So given your justification for why to be originalist in this context, doesn't it actually suggest you should be originalist perhaps in that first decision about whether it's a rule or standard?
Richard?
So I'm not sure whether you mean this or not, but one possible interpretation of the paper would be that if you look at provisions of the Constitution, they are pretty self-evidently either rules or standards. And if they're rules, we want to know what the original meaning was, and if they're standards, we sort of give up on history at that stage. Whereas I would have thought that the way constitutional adjudication more typically works is that somebody raises a question under a particular provision, and then you look at the provision, you look to the meaning of the provision, you look to the history of the provision, and with respect to some questions, you think that the history yields rule-like answers, and with respect to some other questions, it doesn't, all under the same provision. So, for example, if you have the due process clause and somebody wants to know what are the requirements of a criminal trial, then there might be some clear indications. It's a rule that the burden of proof has to be on the prosecution. If you're talking about what constitutes due process, same phrase, same provision of the Constitution in an administrative proceeding, then you might find, well, that hadn't been thought out, or that was left only in a standard-like form. With respect to the First Amendment, if the question is whether a prior restraint is permissible, you might think, well, no, that with respect to that, the original public meaning, original practice yields a clear answer, and no prior restraints. If what you want to know is whether it is permissible for the government to impose some other kind of restriction, then somebody might think, well, that's just vague and standard-like, and somebody has to recur to purposes to explain it, and so forth. I could tick off many examples. Some that occur to me are under Article 3 of the Constitution, what's a case or controversy, what's not a case or controversy. Some are under the Equal Protection Clause. I could go on. But again, I'm not even sure that that's what you mean, but it's one way to understand the paper that that is what you mean. And if not, then I guess the alternative reading was that after the court decides that the only way to resolve a question is in standard-like terms, at that point it gives up on the history. But if that's what you were trying to communicate, that didn't come through to me.
step three.
So I'll try to be brief. I'll start where Dick Fallon left off, and just say two things. One, and I think this is an important piece of the paper. I'm not envisioning a two-step process where, okay, is this rule or standard? Step one, what do I do? Step two. I think that the way in which one is motivated to answer a question has some reflexivity as to how one evaluates the question of rule versus standard. And this gets into this question of, do we see instances of debate? Yes, because we would expect, if I'm right on the positive evidence, or maybe I'm not, but if I'm right on the positive evidence, we'd expect the question of rule versus standard to be a site of contestation. You'd expect rule versus standard to be subject to motivated reasoning. You would expect all those things, and I don't doubt that we see that. And we do. I could cite, and there's some in the paper, instances of that kind of debate. There's a question that I don't quite deal with, but gets a little bit to Dick Fallon's point of there are certain provisions or questions that I treat in standard-like terms, but that have kind of paradigm cases embedded within them. So prior restraint in the First Amendment is an example of that. So one could describe that as saying there's a rule within the First Amendment. First Amendment is hard to apply in the margins, but there is a rule embedded within it which says Congress may not pass a law that counts as a prior restraint. I have trouble, so I think that is probably a rule, but there aren't cases that raise the question of whether the First Amendment forbids prior restraints, right? That's a fairly straightforward, non-textualist, but fairly straightforward rule in the Constitution. The kinds of questions that one sees is whether X, Y, or Z practice counts as a prior restraint. And that's a different kind of question. And I think typically, and I haven't gone through all the cases, but I think typically you see, you don't see how would the framers have understood this there. But that's not in the paper, and that's something I need to do more thinking about. But I did not mean to suggest the first option that Dick put forward, which is in any given with respect to any given case or provision, you have some fairly well settled specified rules and other things or standards. I haven't quite worked that out. Maybe I'll stop and take more questions.
Okay. Naomi Rao, Richard Ray, William Daley.
Okay, so I share, I guess, some of the skepticism that the cases can be mapped onto a rules versus standard distinction, but I wanted to suggest a different positive explanation for the cases that you mentioned, which I thought was interesting, and I'm wondering what you think about this, which is that almost all the cases you refer to that use originalism deal with representative government, sort of the original social contract and what the legislative power is about. And so that explains, for instance, the Powell case, which is about qualifications. It explains the Arizona Redistricting Commission, right, which is how do we choose who our representatives are. Chadha is a case like that. Even Myers, if you think about Myers, not just about executive power, but also about the fact that it's about a statute that gives the Senate removal power. So what are the Senate's responsibilities over the removal of executive officers? So I don't know. I mean, I haven't looked at all the cases, but it struck me as I was going through your paper that a lot of them could be explained in that way, which I think is actually potentially very interesting, that originalism is used to answer those questions about representative government.
Richard?
I want to go back to Steve's exchange with you about the standing argument at the end of the paper. I really liked seeing the idea that justiciability doctrine could kind of be the handmaiden to a constitutional theory as opposed to an output of the constitutional theory. I think that's an interesting idea, obviously in tension with how Scalia would approach the issue. But it struck me that assuming that the point of this is that there is this incongruity or problematic implication given your interpretive theory for a certain principle of justiciability, that we can only really get a handle on that if we know a lot more about the larger range of other practical considerations that underlie whatever is your understanding of the role of the justiciability doctrine. And I guess just briefly, two ways that could come up. First, what is the limiting principle here? What are the countervailing interests that usually do counsel in favor of deferring consideration until later, but not in your view? And second, why is the implication of your vision of standing doctrine limited to these institutional standing cases? I would think it would be much more broadly applicable. And so giving a more contextual view of the relationship between these two pieces of the argument, I think, would make both stronger and be really interesting.
And William Daley.
Just a couple of thoughts of things you might wrestle with if the project remains of interest to you. It's always bad to say this paper should be 150 pages instead of what it currently is, but maybe you'd write another one. One is a primary motivating factor for many of us who identify as originalists is the rule of law consideration, which is why the 35 case continually comes up, the bicameralism, right, of the congressional branch. That is to say, some things are so clear in this document that it's ineluctable. We could imagine what the purpose of 35 was, right? Maybe we wanted to get 17 years past adolescence, and so today a faithful court might have to put the age up closer to 60, right, given what we observe about human behavior. But we won't do that because here's this very clearly expressed bit of law, and it's got to be treated as such. And so we're not going to, and so I think wrestling with the rule of law as the motivating factor for people and judges who behave in an originalist fashion might change the way you're coding cases or thinking about how they approach problems. And then I suppose not completely related to that or directly flowing from, but another phrase that doesn't appear as much in your paper as I would have expected would be stare decisis. It's there a bit. But one way of thinking about the freedom of the court to go back and look at things from the original, or the necessity to go back and say, as a matter of interpretation or application, I liked your response on that distinction actually, is if there's already a great thicket of precedents, maybe that's going to affect the way we see, does the court appear to be behaving originalist? They may feel constrained not to be, they may feel the work's already been done, but that would be a different coding variable than the nature of the problem presented as between rule or standard, for instance.
Okay, that's three.
Okay, one, so representative government, I think those are the provisions, those tend to be the provisions where we'd expect to see the Constitution designed to promote settlement and coordination. So I think that correlation makes sense, and I agree with it. I don't think it's limited to those. So I do think that there are provisions implicating individual rights. I even maybe somewhat controversially characterize Heller in these terms as a rights conflict that actually does implicate a rule. Now, of course, there are structural elements there as well, but I think it's useful. I think you're right about representative government, but it goes beyond that. The standing argument, and Richard, we need to know more about the sort of costs and benefits. If we're putting a practical argument up against a kind of a basic textual or originalist argument that's not designed to be functional, maybe you need more considerations. I take that point. As I understand the rationale for limiting standing in limiting legislative standing, I don't see a lot going for it other than a story that I think is not a great story about a kind of originalist story, although it's a really anachronistic originalist story because it's a story that we're telling about a history of litigating cases in federal courts that doesn't preserve a role for public law litigation, really. So I agree that to make an ultimate case as to whether one should have or not have legislative standing in any individual case, you need to know a lot more than whether we're talking about a rule or a standard. But the fact that we're talking about an institution, I think the paper is really meant to suggest here's a reason you might not have thought of as a good reason to allow this kind of standing at this point in time. It doesn't answer the ultimate question. Why limit it to institutional standing? I don't think one necessarily has to. So I think the argument does go broader than that, although I think there are other reasons to limit standing, right? So again, going back to the first answer, the part 4 of this paper is not, here are the reasons you should allow standing and here are the reasons you shouldn't. There are lots of good reasons to limit standing, and I think that those reasons tend to be decisive in individual rights cases. We don't tend to say, well, because it's an individual, we're gonna delay or wait for something else, because that's already the paradigm case. My point is that we should treat institutional standing in exactly the same way. So I'm trying to catch it up. Rule of law, I think rule of law could show up in this paper. I use the word fidelity a couple of times. I don't flesh it out very much, but if I had to articulate what I think the instinct is that's underlying this practice, I think rule of law probably does capture a lot of it. So I think that's right. Stare decisis, you know what? Again, this is something else I could say more about in the paper, I think. I think it's the case that rules are often successful at settling things. Well, I'll say two things, actually. One is I'm open to hearing more sets of cases where we're talking about a rule that's decided at some point in time, and then there's a whole thicket of precedents that moves in some direction. I haven't seen that really. A lot of these cases I'm looking at are cases of first impression, and then things don't change after that for good reasons, because we're talking about rules. The other thing I'll say is I think standing has been relaxed over time, right? So that I sense, and I haven't done any real empirical work on this, but I sense, and I think others sense, a kind of secular trend in the direction of more cases implicating institutional actors. What you might have thought was a political conflict in the past ends up in court somehow today, and so maybe there's a bigger set of cases that are in that implicate rules in the last 50 years than there were before that. I don't know the answer to that question, but I would have that instinct.
We have about 4 minutes left. So we have Stephen Semorano, Thomas Lee, and John Harrison.
So my question goes to what the ultimate claim of the paper really is. If you're saying there's a constitutional culture that sometimes uses originalist-like methods and sometimes it doesn't, and we can draw the line between it depending on whether the judge understands the question to be related to a standard or a rule. And my question is that something that is deterministic, that things hit a judge at an understanding goes one way or the other, and then the judge is kind of compelled to do it that way? Or is this just a rhetorical choice that when you feel that you can make your point more powerfully by describing something in a rule-like way, you're going to use originalism, and vice versa?
Small point, I wouldn't code Chisholm as an originalism opinion. I mean, the only one that kind of is Ardell's opinion, and he's a dissenter. And this is a suggestion, but I would jettison the rule standard formulation. I think that you're onto something, but it's just too confusing, and it brings in other kinds of considerations. I think your thesis is that in some subset of cases, originalism is as a positive matter and normatively more compelling. And I identified two types of cases in your analysis. When I teach Fed courts, I begin with Tidewater, and I think Tidewater is the paradigmatic example. Either D.C. is a state, as that word is used in Article 3, or not. Once that gets decided, it's done. Your example like that was Cherokee Nation, and that was, is an Indian tribe a foreign state, as that word is used in Article 3? You're done, but you actually weren't done, because essentially in Blatchford in 1991, the question there was once the state sovereign immunity had moved beyond the words of the amendment, the question is, can an Indian tribe independently sue or on its basis? So I think that's one set. And Canning is kind of like that, although once you've decided sine die isn't enough, you could continue having new hypotheticals. So it's functionally something where once that first decision is made, it's done. The other is this, and I think Naomi hit it, like bicameralism, electoral college, apportionment, these sort of design questions that are sort of timeless, and we all know that they were very well thought of and conceived of and debated ad nauseum at the convention. I'm just wondering if that's, if I would recommend strongly that you get rid of rule versus standards as a formulation, but I think your thesis is on something.
John. If you had enough time and enough research assistance, what would you do? Formulate the hypothesis with rule or not rule as the independent variable, appearance of originalist evidence as the dependent variable, 30 or 40 other possible explanatory variables, write the model, code the cases, see what you get, or go data mining. Sort all Supreme Court decisions into those in which originalist evidence appears and those which originalist evidence doesn't appear, and start reading and see what you find.
Okay.
Last word.
Am I talking about something deterministic or rhetorical choice? I think rhetorical choice, but one that's constrained, just like all rhetorical choices are by what's persuasive or not. So there are some provisions of the Constitution where it's hard to make the case that it's either is a rule or isn't a rule when the consensus goes in the other way, and you have to work hard to do that. And I think you observe that in cases. Is Chisholm originalist? I think it's a hard question to answer. Originalist on the I think it's clearly not originalist if you think of originalism as a certain thing, and it really doesn't matter what the thing is. If it's just one thing, then Chisholm doesn't count. So the definition that I'm using, which is really, are we focused on what the framers would have done in 1788 or whatever the relevant provision is, then I think it's hard to say because it's so soon afterwards that it's just too muddled to make that to answer that kind of question. So I concede that it's not the best case, but I think it's plausible that it is originalist on that definition. I'm not going to jettison the rule standard distinction, I don't think, but I take the point that it's confusing. But I also think it captures something. It captures an instinct that we have about the sorts of constitutional provisions that settle things and the ones that are not designed to settle things. And I think I do need to be more clear about, and clear further up in the paper about exactly the parameters of the language I'm using, but I think I'm going to stick with it. And if I had unlimited, so I wouldn't do the empirical project even if I had unlimited research. But I don't want to fight the hypothetical. I think I'd do the data mining because I think that'd be the right way to do it. I have an instinct about this, but I could be wrong, and I certainly concede that possibility. So I think I'd want to take every opinion, figure out what it means to code something as originalist on my methodology, and then see what kinds of other features we can attach to that set of cases. So that's what I think I'd do, but I'm not going to do that.
So we should thank Jamal and thank Michael.